during my 9.5 years of service in the Supreme Court, I have more experiences in terms of judicial and administrative works. Judicial because I've been working on all my cases for 9.5 years, and administrative because I've been involved in so many administrative works, being chairman of the subcommittees on commercial courts, chairman of the subcommittee on family courts, chair of the second division, chair of the Senate Electoral Tribunal, and I have various activities to attend to, like I am the president of the Philippine Women Judges Association and also the co-chairperson of the technical working group on cross-border disputes involving children. So I think in terms of experiences, I have more because of my longer stay in the Supreme Court.
Okay, Justice Bernabe, kindly define leadership.
Leadership is a position that would give you the opportunity to set the policy directions of the court, and it is an opportunity also to create or bring about an institutional change. When you are a leader, then you will be more in a position to see what directions or what policies, plans, and programs you would want to pursue under your leadership.
So, given that definition, what kind of a leader are you? Are you a compassionate one? Are you a leader by example? Are you firm? Are you decisive?
I am a leader by example in the truest sense of the word. My track record would speak for itself, that I have been with the Metropolitan Trial Court as my first judiciary appointment, and I rose up from the ranks to the RTC position, Court of Appeals Justice, and now to the Supreme Court.
Okay, Justice Bernabe, that was my last question. Thank you for your time and good luck.
Thank you, Your Honor.
Thank you. Thank you, Judge. The next to interview the candidate will be the Honorable Justice Noel Jimenez Tiham. Justice Tiham, sir. Attorney Lea, andyan ba si Justice Tiham?
Channel 4. Channel 4.
Your Honors, Justice Noel Jimenez Tiham got disconnected. In the meantime, we will proceed to the next interviewer, the Honorable Judge Toribio E. Ilaw.
Okay. Is Judge Ilaw ready? Judge Ilaw?
Yes.
Okay, the next to interview the candidate will be the Honorable Judge Toribio Ilaw Jr. Judge Ilaw, sir.
Yes, thank you, Attorney Aricheta. Yes, good morning, everybody. Yes, good morning, Justice Bernabe.
Good morning, Your Honor.
we had extensively interviewed in the past. In fact, you had been shortlisted twice. That was on the for Chief Justice October 2, 2019 and November 23, 2018. But you were not, unfortunately, appointed. Do you think you will be appointed this time?
I defer to the presidential prerogative to appoint Your Honor, but I hope to get appointed.
All right. How do you perceive titles or positions? Are they important?
Your Honor, to me, are you referring to the position of a Chief Justice, Your Honor, just in general titles?
No, because I observed that all correspondences coming from your office should contain Senior Associate Justice.
Because that is the title that I have now, Your Honor. But to me, I equate title to responsibilities. So I think the title is not as important as the responsibilities attached to the position.
All right. If appointed, you will be the chairperson of the Judicial and Bar Council. Have you thought of some projects that you will pioneer in this council?
Yes, Your Honor. I think I would digitize the records of the Judicial and Bar Council so that the requirements for the applicants would not be repetitively asked. And also with the projects that I have in mind, like the Judges at Large Act and fast tracking also the implementation of the Family Courts Act, I think we would need more personnel within the Judicial and Bar Council to expedite the processing of the applications for judicial positions.
How will you lead the council?
I will be leading through collaboration. The officials of the Judicial and Bar Council, including you, Your Honors, will be asked to suggest how we can improve further the office of the Judicial and Bar Council. So it's going to be, my leadership is going to be through a meaningful collaboration with you.
All right, you stated as your long-term plan your intention to create a system of stabilizing court decisions, emphasizing in view of conflicting jurisprudence. How would you do this?
I will coordinate with law schools, Your Honors, and ask them to analyze court decisions. And since law schools are more concerned of the history of cases, they would be able to easily identify which decisions are conflicting and which are not. And they would present to the court these jurisprudence when the time comes for the proper case to come to the court. Then we can overturn or we can choose which decision is really one that is more adhering to the Constitution and the law.
That is shifting such responsibility to the schools. How about, would you
No, Your
look
Honor.
after the ponencia?
It's
Yes,
just
please.
going to be an analysis, Your Honor. They will not suggest anything. It's going to be just tracking the history of cases.
Don't you think that will be or dangerous to having gravely criticized your the ponencia of your fellow justices? Imagine just to inform them of their perceived inconsistent ruling.
I don't think so, Your Honor. I think most of us, the members of the court, would really want jurisprudence to be stabilized.
By the way, what do you think is the foremost purpose of a Chief Justice?
The purpose of a Chief Justice, Your Honor, is just to really set the plans, programs, and initiatives of the court, put them into motion, implement them towards the vision of having a court that is responsive to the needs of the people, a court that is independent with integrity and unified.
One of your short-term plans is stated that is to streamline internal court procedure in the Supreme Court to expedite the release of promulgated decisions, resolutions. Could you explain this further, please?
Your Honor, when we promulgate decisions at present, it takes a long time before these are released. And I've checked on it and saw that it stays with the Office of the Justice for a longer time than usual because of the proofreading. And then after proofreading, it comes to me, and there is another process of proofreading, and it goes to the division clerk of court, who also proofreads these decisions. So it takes a longer time, probably 1 or 2 months, to get these decisions released. So I want to streamline this court process and evaluate the problems and see what I can do to effectively release them without delay.
Do you think that a Chief Justice is a justice of ordinary motivation with extraordinary institutional prerogatives? That is, a Chief Justice who is motivated by some personal taste in legal reasoning, but has tools available to advance his her interests, which are not normally available to other justices.
No, Your Honor. I don't think the position of Chief Justice would call for advancing personal interest. It is just like any other position of an associate justice, where you have to really do your functions by interpreting law in accordance with the law and the Constitution. And insofar as administrative works are concerned, it should be beneficial to the welfare of all the litigants, the parties, and the employees.
Chief Justice John Roberts is said to adhere to prudentialism as he takes limits on judicial authority seriously, appreciates the need to respect the task and authority of other institutions of government, and whose general watchwords as a judge are modesty and humility. If appointed, what judicial ideology or philosophy would you espouse?
Judicial philosophy in terms of deciding the cases, is that what you mean, Your Honor? Because that is our duty to decide our cases. So my judicial philosophy would just be, I can just be a textualist. When the law is clear and the intent is clear, I interpret the law in accordance with the law and the intent of the framers. But when the law is vague and the intent could not be determined from the framers, then I would apply reason and logic, the societal implications of the ruling, and also the fairness, most of all, of the court's ruling.
All right, there's a pending case before the United States Supreme Court involving free exercise of religion and free speech. A nonprofit adoption and welfare agency was barred by the city of Philadelphia from placing children in foster homes because of the agency's policy of not allowing same-sex couples to be foster parents based on religious grounds. Because of this, the agency sued the city of Philadelphia and argued that each policy is an exercise of its right to free exercise of religion and free speech. So if this case is brought before you, how would you decide it?
Can you repeat the question again, Your Honor? It's quite a long question.
It is, remember the case of Fulton versus City of Philadelphia. Have you come across
No,
this
I'm
case?
not familiar with that, Your Honor.
All right. Anyway, let's go to another subject. The judiciary is an institution dedicated to public service. How would you ensure the quality of service rendered by the judiciary under your leadership?
Your Honor, of course, I assume that all the employees, all the officials, the judges, especially the judges appointed by the Judicial and Bar Council have all been vetted. The applications have all been vetted, and they are supposed to be persons of integrity, probity, competence, and independent. And therefore, Your Honor, I have that assumption, and if ever there are complaints against them, we have accountability mechanisms in place, like have the Judicial and the Judicial Integrity Board, and we have the JPAS, the Judicial Public Service Sector, created by the chief, so that all complaints can be coursed through these agencies. And also, Your Honor, we also have the field jump, where judicial ethics should really be taught as the cornerstone of the judgeship position. And I think trainings on anti-corruption measures should also be addressed by the Philippine Judicial Academy.
All right. In your dissenting opinion in People versus Pagal, you stated that our current procedural framework must be revisited so as to codify the proper searching inquiry guidelines and other relevant procedures the trial judges must follow whenever an accused pleads guilty to a capital offense. So aside from guidelines on searching inquiry, what other amendments to the rule on criminal procedure do you think would be necessary?
Your Honor, I think the Chief Justice has already spearheaded the rules on criminal procedure, and it's going to come out very soon. So can we just await, Your Honor, the amendments to these rules?
Any additional amendments that you would suggest in line with your dissenting opinion in that People versus Pagal?
Your Honor, this involves the let me refresh my memory, Your Honor. I think in this case, I was asking for the remand of the case to the lower court, to be able to, for the court to conduct a more searching inquiry about the plea of guilt of the accused in a capital offense. So I think this was, I think, done before well, Your Honor, I think the judge should really be more more detailed in his questioning on whether or not the accused understands the consequences of his plea of guilt to a capital offense. So there should be more guidelines and more questions, not just the pro forma questions that the ordinary judge would ask of a person accused of capital offense.
Because just to refresh your memory, Justice, in the said case of People versus Pagans, the Supreme Court, through the ponencia of Justice Alex Gismundo, ruled that an accused plea of guilty alone, the capital offense, does not amount to a judgment of conviction without evidence of proof beyond reasonable doubt. So you mean to say that you go as far as this ponencia of the Supreme
Your
Court
Honor,
in this
yes,
case?
no. Because in this case, the prosecution was not able to present any evidence anymore because, first of all, there were the complainants, I think, were not informed of, they were not subpoenaed on this case. And there were so many settings of the hearings, but none of the complainants appeared because they were not notified. So my suggestion here was to remand it to the lower court and give the complainants the opportunity to really present evidence to prove the guilt of the accused beyond reasonable doubt. It is not the fault of the complainants that the prosecution was not able to inform them that hearings were going on. That's why I wanted a remand of the case, and the judge, I think, should be more cautious about this. That the negligence of the prosecution should not bring about the acquittal of the accused charged with a capital offense merely on the basis that there were no, the complaining witnesses were not given the opportunity to present their side.
If you're going to follow such your dissenting opinion, simply you're going to remand the case. That is this for trial de novo.
Yes,
going to go back
to give the prosecution a chance to present their evidence, because in this case there was no evidence at all, and I think the complaining witnesses were not even notified of the hearings that were set by the court.
All right, let's go to another case. In the case of Madreo versus Meeron, the rule is that the condonation principle applies to recall elections. In your dissenting opinion, however, you emphasize that the condonation principle applies only to regular elections. Being a senior associate justice and the ponente of Carpio Morales versus Court of Appeals, which abandoned the condonation doctrine, why were you not able to convince your fellow justices to adopt your dissenting opinion?
Well, convincing them, Your Honor, is, I mean, they have their minds on it. So I just give out my reflections and I give them a free hand to vote for or against the ponencia. But I guess one of the considerations for this is just is that recall elections would never happen again for the condonation doctrine to apply. But I still am convinced that the condonation would not be applicable to recall because recall elections was never considered in the application of the condonation doctrine before. It was just a regular elections, and therefore there was no way we could really apply it and expand the meaning of condonation doctrine to include recall elections. They never existed in the past. There was never the prospective application of the doctrine could not have applied to something that never existed in the past.
All right, my last two questions. How old is your husband, Ricky?
My husband is already 71, Your Honor.
71. How many birthdays does the average man have?
7 average birthdays, Your Honor, meaning the lifespan.
Yes.
Well, I think he will live long enough, Your Honor, as his mother. His mother died at the age of 100, so I think he has a pretty good life. He has a pretty long life in his genes.
All right, that was my last question. Thank you, Justice, and
Thank you, Your Honor.
good luck.
Thank you, Your Honor.
Thank you, Judge Ilaw. The next to interview the candidate will be the Honorable Justice Noel Jimenez Tiham. Justice Tiham, sir.
Yes, thank you, Attorney.
Thank you, sir.
Good morning.
I
Good
was
morning,
on
Your Honor.
internet connection for a while. Good morning, Chief Justice Telly.
It's nice to hear that, Your
I have
Honor.
known you for many years. You are more than qualified to become a Chief Justice.
Thank
The
you.
purpose of the public interview is to show to the public what kind of a Chief Justice you will be. Now, Dean Serafin Cuevas from the New Era University wanted to find out whether you will be an activist, reformist Chief Justice, or you will be a moderate, conservative Chief Justice.
Your Honor, judicial activism is a judicial philosophy that holds that you can go beyond the law in order to consider some societal implications. I cannot be a judicial activist if the law is clear and the intent of the framers is clear, because I would run afoul contrary to the separation of powers that is going to be considered a judicial legislation. But if the law is vague and the intent is not clear, then I can be a judicial activist, meaning I could look at the societal implications of the ruling, the impacts on society, as well as I will exercise reason and logic and fairness in my decisions.
Now, before I go to my other questions, I'd like to read a question that was forwarded to the JPAS. The question is, are you in favor of publishing the SALA of members of the court, provided it conforms with the Data Privacy Act? That's not my question. That was a contributed question.
Well, for me, Your Honor, I have really nothing to hide. It's just that sometimes people tend to criticize or to find ways and means to really destroy the reputation of a justice. And so I think this summary of the SALN would just be enough. And if there are cases or there are complaints against the justice, then I think the complainant should really file a case in the proper forum.
Do you subscribe to the statement of former Supreme Court, retired Supreme Court Justice, now Ombudsman Martires, that to a certain extent, the SALN has been weaponized?
To a certain extent, yes, Your Honor, because sometimes a justice is a person of integrity, of competence. I mean, he has all the qualifications of a justice, but it might come to a point where the SALN can be used to destroy his reputation. And the justice will be just so busy defending himself or herself.
Talking about the SALN, after I penned the decision in Republic versus Sereno, which, by the way, you dissented from, and this allowed President Duterte to appoint 3 Chief Justices within a span of 3 years. The question is, when you are appointed as Chief Justice, will you serve out the term until you reach the age of 70? Or will you also opt for early retirement to allow the appointment of a 5th Chief Justice?
I haven't given a thought to it because I have not been appointed as yet.
Now, the other inputted questions, I don't know if this was already asked because I was out of the internet connection. The question of Justice Francis Ardilesa, was that asked of you already? Not yet?
Not yet.
Justice Ardilesa, who, by the way, is watching this public interview, wanted us to ask you whether Article 8, Section 15 of the Constitution, which provides that all cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission to the Supreme Court, whether you consider this mandatory, by way from your personal perspective, whether this is mandatory or directory. And I'd like to premise that by saying that all of the Supreme Court justices are burdened with work. Okay, but do you consider this provision mandatory or directory?
Your Honor, the court sitting as a collective body has already ruled in the case of, I think 2019 case of Enables, that this provision, Section 15(1) of Article 8 of the 1987 Constitution, is directory in nature insofar as the members of the court are concerned. And the reason cited was the Supreme Court should be given ample time to deliberate on issues to ensure that the litigants' rights are protected, especially the public interest cases. But notwithstanding this current jurisprudence, I recognize that the court should really strive very hard to find the most efficient way of disposing cases. And therefore, if appointed as Chief Justice, I will explore means and ways to really visit the internal rules, conduct a holistic study of it, streamline the court processes so that I will be able to strike a balance between the right to speedy disposition of cases and the practical logistics of the court's heavy dockets and institutional capabilities.
But corollary to that, appellate courts, other appellate courts and lower court judges are also bound by periods within which to decide. Should there be a uniform or a common standard of compliance and a common standard of sanction? Because I recall there was a Court of Appeals justice, I will not mention the name, who was sanctioned by the High Court for failing to decide a number of cases, admittedly, when she was still a regional trial court judge. From the public perspective, there is seemingly a different standard of compliance and sanction. Does this violate the Equal Protection Clause?
I don't think so, Your Honor. Actually, we have to also recognize that the perennial challenge of the judiciary is really how to decongest the dockets of the court. And the lower courts, even the appellate courts, for as long as there is justifiable reason for non-compliance, they could really ask extensions from the Supreme Court to extend the deadline of the resolution of their decisions. In the same manner, the Supreme Court also asked for extension. That's why I think you're very familiar with our 3 months call again, a phrase that we use in the court to extend the deadline of our decision-making process.
You have no objection to monitoring the status of pending old age cases and making it public. Is there any constraint to making it public so that the public will know?
Well, the public, of course, certainly will open the Supreme Court to criticisms. For me, I don't really see any problem because I do not have an age case since 2017. But for the other new appointees, there are age cases which were just passed on to them, and they need time to go over the records of these cases. So I don't think they'll be able to comply at this time with the 2-year requirement of the Constitution if assuming that it be made mandatory. So I think we just have to give them more time, and I will see to it that these age cases will really be resolved, or there's going to be some kind of a program for this during my term.
With the advent of vaccine nationalism and the dearth of supply of vaccine, when you are appointed as Chief Justice, what brand of vaccine will you recommend for the judiciary?
Actually, I'm confused already about the details, the implications of all this vaccine. So I still have to further study the effects of each vaccine and whatever and the age, the material age for each vaccine that will be suitable for each employee.
But as a logical, a rational lay person, not as a magistrate, aside from vaccination, is there at present another cure against COVID-19? As a lay person, it seems that vaccination is the thing available, correct?
To me, I think if you already have a pneumonia flu vaccine, I think your immunity system is already going to be very strong. Because to me, the COVID-19 is somehow really related to pneumonia. But right now, I think the safety protocols would just be set in place in order to ensure the health and welfare of the employees.
Now, the palace And even the Department of Labor and Congress have stated that each citizen has a constitutional right to refuse immunization or vaccination against COVID-19. Do you subscribe to that, Your Honor?
Yes, because
Sure.
the right to health is a constitutional right, and I think employees should be given the right to refuse or not to refuse this vaccine,
So
so
if
that
a,
the vaccination should
if
just
a
really.
an employee of the judiciary refuses to be immunized, inoculated, or vaccinated, will you allow that employee to go back to work if you are Chief
Yes,
Justice?
but I think I will be more strict with the safety protocols for that employee.
Notwithstanding Article 284 of the Labor Code, which says in case of serious illness or if an employee is suffering from any disease, the employer may terminate the service of an employee. Isn't it important that you also look into the health and well-being of the other employees within the judiciary?
Yes, I agree with that, but I think the right to health would still be important for this purpose.
Do you encourage judicial legislation, Your Honor?
Well, definitely not, because it will breach the principle of the separation of powers. And I
So
think
judicial-
Congress and the executive will be mad with us doing that.
Judicial legislation violates the Constitution and the principle of separation of powers.
Yes.
Do you agree with me that judicial legislation may amount to culpable violation of the Constitution and therefore an impeachable offense?
Well, in a sense, yes.
Because what is more clear is to violate the principle of separation of powers. So how
Yes,
will,
I
as
agree.
Chief Justice, how will you discourage judicial legislation?
I will not only discourage it, I will prevent it from happening.
What about the Subjudice Rule, Your Honor? How will you balance it vis-a-vis the right of the public to know, the freedom of expression, the freedom of the press to make comment on issues before the court? Because at any rate, judges, magistrates are trained not to be influenced by external forces.
The Subjudice Rule is limited in its application. It will only apply if it tends to influence the judge or the justices in rendering its decision. So if it doesn't go to that extent, then I think you can really talk about the case, and that's not going to violate that's going to be an expression of that's going to be in pursuit of your freedom of expression.
Now let's talk about a decided case already concluded, the Marcos versus Robredo pet case, without going into the merits of the decision because the court has already spoken. On hindsight, and in your opinion, it took the court 5 years to make a declaration that the petitioner failed to produce evidence of electoral fraud. What could have been done differently on hindsight, only for purposes of academic discussion, to fast track the resolution of that electoral protest?
No, the electoral protest contains volumes of records, and I cannot blame the ponente for not deciding it as quickly as possible. You may recall that this used to be handled by Justice Kadiwa and merely passed on to Justice Leonen. And when it was passed on, he has to review the voluminous records of the case again. And he has to be very careful because this is a political, somehow it has a political color. And he was very careful in deciding this case. But you are asking me if I were the ponente, how would I decide it quickly? Well,
Without casting aspersion on the opponent, what could have been done differently? I mean,
yeah, it could have been done differently.
finding out that there's no
It really depends. It really depends on how.
Look for the evidence. Isn't it that the petitioner is supposed to produce the evidence? And if there is no evidence, then the court should have dismissed it outright.
Yes, and in fact, that was what Justice Leonen did. Insofar as the third cause of action is concerned, he went through every piece of evidence without saying that we should reopen the third cause of action. He made sure that if the case was reopened, he would come out with the same conclusion. That's why it took him a while to resolve the case, because he has to go through every piece of evidence that were presented.
Now, when you decide policy cases where the executive branch has the responsibility of protecting national security, as Chief Justice, how should the Supreme Court balance the interests of the executive, expertise in national security matters, vis-a-vis the judiciary, constitutional duty to enforce the Constitution and prevent abuse of power?
Insofar as policy matters are concerned, there is somehow a deference to the President's executive power, but we can also check that if the exercise of this power is within the bounds of truth and reason.
You have heard about the doctrine of purposeful hesitation in deciding the constitutionality of the law. A law is passed by Congress, and there are lawyers in Congress. They're supposed to be conversant of the Constitution. Should the judiciary right away look into the language of the law, whether the law violates the Constitution, even in the absence of an actual controversy?
Are you saying that even before it is
That's a
passed?
hypothetical question. That is not an actual, it does not pertain to an actual case.
Meaning before it is passed, we should look into it already? Or
After Congress
after it is passed?
petitioners went to the Supreme Court questioning the constitutionality of that law because the language of the law violates the Constitution. Should the court adopt the doctrine of purposeful hesitation, considering that the law is presumed to be valid?
We do not handle a case when it is not right, when there is no actual controversy. And therefore, when a law is passed and there's no case before us, then we do not give advisory opinions on this.
My last question is, the court in Geo Summer has clearly delineated guidelines where litigants and lawyers can go directly or make direct relief and seek direct resort to the court. Do you adhere to the doctrine of justiciability, or are you willing to accommodate in certain cases the doctrine of capable of repetition, evading judicial review? In other words, even if a case has already become mooted, if it is capable of repetition, evading judicial review as Chief Justice, will you direct the bank
Yes,
to consider it?
yes, I think we should do that so that we can settle once and for all issues that are really important and that will guide the bench and the bar and the public of this of the rulings of the court on this. So it will not come up again.
Similar to an advisory opinion? Is that not similar to an advisory opinion, since there is no actual controversy anymore And yet, you
But
would like that
we have
doctrine of
crafted exceptions, Your Honor, and this is one of the exceptions to taking cognizance of a case that has been mooted.
All right. Thank you very much. I have read the long-term and short-term plan. I think we will flash it during the break, and this will be shared with the media and to the public. Okay. Thank you
Thank
very
you,
much, Your Honor, and good luck.
Thank you.
Thank you, Justice Tiham. The next to interview the candidate will be the Honorable Justice Jose Catral Mendoza. Justice Mendoza, sir.
Yes, good morning, Justice.
Good morning. Good morning.
This is your second time. I forgot what I asked you before. I think I did not ask you questions before, right? Did I questions
I
before?
think you did, Your Honor,
What did I cover?
about my cases, my judicial philosophy.
Okay, I think, well, the questions or the areas I want to cover were already covered by my colleagues, but I want to ask some questions or follow-up questions with respect to your previous responses and what you have written in your short and long-term plans. But first, I would like to ask you, what is your understanding or perception of the position you have applied for?
Well, the
What do you
position
think of its power and its limitation?
well, to me, the office of the position of the Chief Justice is not just a pinnacle of the professional career, but rather it is one once in a lifetime opportunity to institute changes in the judiciary. It is a position that requires meaningful collaboration with all the stakeholders. It is not a position of superiority, but rather one of a position that involves consultations with the other stakeholders of the court. The problems of the court are deeply rooted and persisting, and therefore I believe that it cannot just be solved by one person, but you need the involvement of many on this in pursuing the plans and programs of the court.
Especially the members of the Supreme Court. You will
Yes,
be the leader, you will be the primus inter pares. What
yes,
are the limitations of that position? You have been in the Supreme Court for 9 years. You should know
for 9.5
them by now.
years.
Yeah, 9.5 years.
I think all the members of the court should be open-minded, just as I will be open-minded to them. And there will be collegiality, respect, and support for all the programs that they would propose, as well as I will encourage them to actively involve themselves in the programs which I will pursue.
Yes, sir. I'm a member of the JBC representing the retired justices of the Supreme Court, most of whom sent questions, and I will propound some of them. But some of them were already covered, like the one asked by Justice Hardelesa. I just have a follow-up point there. The complaints of trial court judges is that the Supreme Court has interpreted the constitutional provision on the 240 days of the 2-year period as directly. But in their case, seems it is mandatory. They ask, why should trial be judges, or why they should be treated differently? Can you answer that? I know your answer to that, but I want you to satisfy them and the public.
The lower court judges are heavily laden with so much cases, and therefore I don't think they could really dispose of their cases within the time frame, except of course for some. But the court is not strict with them in the sense that if there are justifiable reasons why they couldn't comply with a period of 90 days, then they could ask for exemptions. And this policy holds true insofar as the appellate courts are concerned, and also insofar as the Supreme Court is concerned. We have any Supreme Court justice can always ask for extensions in the deadline within which
in the Supreme Court it's called
their decisions.
3 months, right? The maximum. Call again 3 months. Call again.
Yes,
months.
yes.
That's
yes,
the maximum.
Yes.
What is
Yes,
the
Your
maximum?
Honor.
Do you think? Can you provide or allow, which you can allow to trial court judges, MTC level and RTC level, because you have been a first level court judge and then a second level court judge, and even in the Court of Appeals.
We have not really set a maximum period for judges to ask for extensions. I mean, they could keep on asking for as long as there are justifiable reasons for the extension.
Okay, it will be on a first case-to-case basis.
Yes, Your Honor.
So, but you will maintain that it, with respect to the lower court judges and justices, the period is mandatory.
Well, effectively, it becomes directory already in the sense that, that they can ask for extensions. Although if they do not present a justifiable reason for it, they may get sanctioned.
I see. You have been with the Court of Appeals and you've been with the Supreme Court. Are you aware of the initiatory pleading, initiatory load of a Court of Appeals justice? What is the rule there, if you remember?
In my case, I think I had about 600 cases in the Court of Appeals.
Now, in the justices in general, a new justice entering, what is the initial?
In the Court of Appeals?
Yes.
I do not know now, Justice, because there are now 69 justices now, but I think the initial case load would be about 300 to 400.
Yes, like before, 300, yes. Oh.
Unlike before when it was higher.
Now, you've been promoted to the Supreme Court. What is the difference regarding the initial caseload?
It's much higher. And the cases that come to us before the Supreme Court are more difficult. The issues are more complex.
Yes, but my question was on the initial caseload of a justice.
It's about 650 is the average.
Yes, average. If the justice you replace had lower load,
then there will be an unloading of cases.
Unloading. Yes. The problem is if you inherited, for example, 1,000 like Chief Justice Persamin, like one of and the justice who replaced Justice Persamin. They have a high caseload, but they just inherited it. What do you intend to do about them? The initial caseload, that is really a problem in the Supreme Court. Well, the others are happy, they just received 650, but the others are complaining because they have received more than 1,000. are your plans, or what are you going to do about it? That is a
Well,
perennial problem. Even I even asked Chief Justice Bersamin about that when he was interviewed, because he was affected. But he declined to answer that because it might benefit him or affect him.
I
It,
plan
might-
to
it could
set up
have
a pool
been
of
self-serving.
I plan to set up a pool of lawyers to assist in the resolution of the AIDS cases. So probably I can give priority, or I can give more concessions to the ones with higher dockets.
Yes. What we did before in this Court of Appeals was to ask the senior justices with few caseloads to help in drafting the decisions and resolutions. And in the Supreme Court, during the time of Justice Bersamin, more lawyers were assigned to him from the Court of Attorneys. But he said he called it, it's really an imbudo because ikaw rin ang gagawa eh. Ikaw rin ang
Yes,
mag-decide.
Your Honor.
Oh,
Yeah.
that's his problem before. Oh,
During the time of yes, Your Honor, during the time of Sereno, there was a program, a zero backlog project, and lawyers there was one lawyer added to each office, and we created a pool for it. Except that the justices found it hard to adapt to the writing style
yes.
of the justice, and so they were not amenable to that kind of a project.
Anyway, you mentioned that you will be creating a committee to study that. Oh,
Yes, Your Honor. I will look into that, Your Honor.
yes. If you would be appointed as the Chief Justice, you will be the chairman or chairperson of the Judicial and Bar Council. Now, recently the Supreme Court and Bank issued a resolution expressing the sense of the court with respect to the requirements of the EBC. In response, we eliminated so many requirements already, and we just left those which need to be updated. Have you read the resolution of the JBC and Bank addressing
Yes, Your Honor.
the sense of the? Oh,
Yes, Your Honor.
what is your comment on that? You will be appointed. You will be our chairperson, and I just want to say that before we decided that, we consulted so many interested parties, even the media and the public, and they want that the candidates be interviewed. And about the other requirements?
I agree that we can dispense with some of the requirements of the JBC, and in fact, that is one of my projects, to digitize the records of the JBC so that it will not be asking repetitive requirements from applicants. Now, insofar as the interview,
we have those one-time requirements already. We have listed them, so we will not ask them anymore.
insofar as the interview request of the justices to be exempted, then I'd like to hear the panel on that before I give out a decision.
Yes. How about the other one-time requirements, or the other requirements which the JBC did not waive? What is your view on those?
I agree with all those requirements, Your Honor.
I see. I was looking at your plans. You mentioned for your short-term plans is to study, expand the scope, and increase the claim thresholds under the rules on summary procedure and small claims. Can the Supreme Court do that?
Yes, Your Honor. This is going to be part of the duty of the Supreme Court to promulgate rules of procedure for as long
But
as
is it not
the
jurisdiction it's conferred by law?
yes, Your Honor, for as long as the jurisdiction is not affected, then the rules of
I see.
procedure can go on.
So you have to ask Congress to increase the threshold, for example.
No, Your Honor, when I say increasing the claim threshold, I am referring to whether or not these rules can be expanded to apply to the regional trial courts.
I see. Okay.
The
Now,
application of the rules, it can be applied to the regional trial courts, Your Honor.
with respect to the lower courts, there has been a perennial problem by trial courts that they are stuck with legal researchers who really are inefficient and incompetent. And if they do not pass the bar, they're stuck with them. And if they pass the bar, they leave the justices. Their proposal is that they be considered only coterminous, but prospective. But the rule should be made
Yes, Your Honor.
prospective. What can you say of this?
I think there are some really employees, Your Honor, that should be considered coterminous with a judge. I've been in the lower courts way back, and I know the problems of the judges now, that there are some clerks of courts and legal researchers and the clerks of courts and the legal researchers who are not so competent or do not come up with their standard. So I think it's better that for newly created courts, the judges will be tasked to hire the clerks of court and the legal researchers.
I see. I am running out of time. Some of the justices submitted questions for us to ask. For example, Justice Boji Reyes, asked about the expedition of the trial, was asking about the how the disposition of the cases can be split up. Now, you earlier stated that with respect to those, you did not mention the word improvident plea, but were you referring to that when you were asked by Judge Ilaw, improvident
Yes.
plea?
Yes, Your Honor. It's an
Was an
improvident
improvident
plea of guilt, yes.
Oh, are there parameters which you can suggest so that improvident pleas can be avoided?
Your Honor, the improvident pleas can be handled properly by the judge for as long as the judge explains very well the consequences of that plea. So I think the judge should really have more searching questions to the accused to be able to determine whether or not this improvident plea is valid.
Also, the Chief Justice De Castro covered the Enterprise Information System plan, which you mentioned in your plan also. For the benefit of the public, viewing public, can you inform them of what this EISP means and what is your plan for its improvement?
Your Honor, the Enterprise Information System was already approved in 2014. And that's why we had this eCourts 1 which were put up in pilot courts. I think there were about 12 pilot courts put up in Metro Manila and some in the provinces. And there were projects. This is the umbrella computerization program of the court, and it covered really everything: the case administration system of the Supreme Court, the lawyer information system, the field e-learning management system, the hearing management system. But unfortunately, there were some kinks in it. It did not work well because there were some security features that became the problem. So they were stopped. It was funded by the Abaroli before, but until 2019 when the COJUST took over it. And there was a review by the COJUST, which is our funder, and they found out that there were really some defects in the system. So this is what we are going to pursue again. We will try to fully execute this enterprise information systems plan, either by getting another software or asking some technological companies to give their comments on what we have purchased already before. So this is going to really fully automize the court, Your Honor.
Okay.
It's just unfortunate that it did not work well.
Okay. Thank you. I'm running out of time. This is from Justice Meeron. What is your most significant ponencia, and what is its contribution to the country, to the Supreme Court, and judiciary in general?
I have two significant ponencias, Your Honor, and these are the Priority Development Assistance Fund, its abolition, and also the condonation doctrine, which was also abolished. I find this very significant because they change the landscape of jurisprudence towards strengthening the court's stance on public accountability.
Okay. Do I still have time? I think in the case of Pimentel versus Levy, it is not yet final.
Yes, Your Honor.
Yes, and you have a separate opinion on it. Can you explain your separate opinion?
Your Honor, I am for the abolition of the PhilSAT exam because when LEB does that, it practically does not regulate the institutions of learning anymore, but exercises control over it in the sense that if you do not pass the PhilSAT exam, you cannot be admitted to the law school, and it violates, therefore, the academic freedom of the schools of this.
I think all of you agreed on that. How about placing, there is a bill now pending in Congress suggesting that it be placed under the Supreme Court. What is your view on that?
Which one, Your Honor?
The LEB. Because the LEB is now under the CHED, right?
Yes,
So
Your Honor.
the proposal that it be placed under the Supreme Court, because after all, under the Constitution, it is the Supreme Court which has jurisdiction over the admission to the bar.
Your Honor, can I refuse to answer that because the law might come to us, and
I see.
I do not want.
No, there is no law. It's just a bill. So I'm asking
yes,
you.
it's a bill, but it might come
opinion
before us. The constitutional that law might come before us, and I might be preempting my answer, and I do not want to be forced to inhibit later on.
Okay. I can understand. May oras pa ba ako? Who is monitoring? This is from, walang sagot eh. This is from Chief Justice Davide. What are your plans regarding halls of justices in the country? Because there are so many judges who have no courts. For example, in Dasmariñas, there are 3 judges sharing only 1 court. What are your plans for those problems?
I have to identify the problems first, Your Honor. Which courts or which judges do not have any courts or any infrastructure. But I will have to identify first the deficiencies in the court infrastructure before I'm able to really
so
solve their problem. But there are infrastructure. There are lots which are being donated already by private individuals, and we have funding for all this infrastructure already. So it's more of an identification of problems before we're able to solve these needs.
Thank you very much, Justice. I have no more time. I have plenty of questions, but I have no more time.
Thank
Anyway,
you, Your Honor.
best of luck.
Thank you, Your Honor.
Okay, Attorney Aricheta.
Thank you, Justice Mendoza. Thank you, sir.
Okay.
The next to interview the candidate is the Honorable Congressman, Justice Vicente Veloso III. Justice Veloso, sir.
Good morning. Good morning, Justice Telly.
Good morning, Justice Congressman.
I recall that when we were at the Court of Appeals, we had this competition on zero backlog. Do you recall that, Justice Telly?
Yes, Your Honor.
Okay. I'll take off from this query of retired Justice Sardinesa. Article 8, Section 15, I'll start with Section 16. I will read it, so there will be no debate on this. It says in Section 16, all Section 16, Article 3 of the Bill of Rights says, all persons shall have the right to speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. And Article 8 reinforces this, and I will read. Section 15. All cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission for the Supreme Court, and unless reduced by the Supreme Court, 12 months for all lower collegiate courts and 3 months for all lower courts. This Section 15, Paragraph 1, has a defining provision. Despite the expiration of the applicable mandatory period, the court, without prejudice to such responsibilities as may have been incurred in consequence thereof, shall decide or resolve the case or matters submitted thereto for determination without further delay. My first question, Justice Telly, is I heard that a lot of judges of the lower court, and in fact, I also know of a justice of the Court of Appeals who was disciplined or who were disciplined because of delay in the disposition of cases. Do you recall that?
Yes, Your Honor.
Therefore, when we speak of the right to speedy disposition of cases, particularly Section 15, this matter of deciding cases within 24 months for the Supreme Court is not only mandatory, it is also punitive. And I will read paragraph 4, it says Section 15 of Article 8, despite the expiration of the applicable mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequence thereof, shall decide or resolve the case or matters submitted thereto for determination without further delay. So if a judge in the RTC or if a justice of the Court of Appeals could be readily disciplined by the Supreme Court for the delay in the disposition of cases, kindly tell this representation, Justice Telly, why the Supreme Court should be exempted from such mandatory and punitive action.
Your Honor, the reasons why these judges were disciplined was because they did not ask for an extension and they could not give any explanation for the delay or for the non-compliance with the period within which they decide. Had they asked extension, the court granted it. Concealed the fact that there was delay in the disposition of the cases. That's why they were sanctioned. Now, everyone can ask for exemption, and there is no limit to that exemption for as long as you are for as long as you ask for it, and you're honest to admit that you have not complied with the mandatory periods resolved in cases. In the court, we also asked for extension. Extensions have been granted by the court sitting as a collective body.
Justice Telly, Section 15, Article 8 provides in Section 15, Paragraph 2, that a case or matter shall be deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of court or by the court itself. So if in a situation there has been no extension, as you earlier explained, granted by the court, and the case has already been deemed submitted for resolution, what further explanation should the Supreme Court require from a trial court judge or from a collegiate court justice, or even for that matter, from the Supreme Court justice who is guilty of delay in the disposition of cases?
For lower courts, they cannot be held guilty of delay if they ask for extension and cite justifiable reasons like clogged dockets of the court or illness or anything that the court would find as reasonable. Now, in the Supreme Court, we asked for extension to call the case again, and the court grants the extension. And I would say that is enough already for the court to effectively extend the expiration of the period. Of course, Your Honor, I understand the right of the people to speedy disposition of justice. And therefore, when I become one I will try to balance this. I will create a reasonable balance between this right and the heavy dockets of the court.
So let me close that window, Justice Telly, by just saying that if submission of a case for a disposition is extended by the Supreme Court, that is already an exception to the mandatory character of Section 15. And if there is no extension made by the Supreme Court, then the Supreme Court justice handling that case can be disciplined under section or by force of Section 15, Article 8. Is that correct, Justice Daly?
That is the inference. That is the inference, Your Honor. But I will look into that, Your Honor, and work on it if I become chief.
Okay. You mentioned in your letter dated March 10, 2021, that you are talking about special projects, initiatives for case decongestion. And you can increase the competency of courts by providing judges with a complete and updated
We are also implementing the Family Courts Act. And once we have implemented this, there will be 183 statutory family court judges. And this will relieve the designated family courts of their family court assignments for them, allowing them to focus on the handling of their own cases.
My last question is regard. A lot of questions have already been asked of you. So you will be retiring a year from now. Is that correct?
Sure.
And you have been known to be a very competent justice at the Court of Appeals.
Thank you, Your Honor.
With a zero backlog. How many cases do you still have that are pending before the Supreme Court?
Right now, I only have 67 judicial cases, Your Honor, and I am unloading. I'm entitled to unload 27 cases, so that leaves me 40 cases to decide.
That would be all, Mr. Chair.
Thank you, Your Honor.
Thank you.
Thank you, Congressman Justice Veloso. Tanilea, close na? Wala eh. That concludes the public panel interview of Madam Justice Perlas Bernabe. Good luck, ma'am.
Thank you. Thank you very much.
Your Honors, shall we suspend the proceedings for this afternoon and continue this afternoon? Secretary of Justice, will you take the interview also?
No, our time is up already. We'll resume with the permission of the chairman this afternoon.
Thank you, Justice. Thank you, Secretary. So that concludes the public panel interview for this morning. We will continue at 1 o'clock this afternoon. Thank you.